Good afternoon, everyone, and welcome back to Digital Law News. This is a weekly webinar and podcast brought to you by Digital Law and produced by Anson Evaluate. So just for those who don't know, Digital Law is a niche specialist law firm, and it specialises in data, cyber and technology and the law relating to that. So I'll just pass over to Peter to just introduce himself and give you a little bit more information about this podcast today.
Thank you, Laura. So my name is Peter. I'm the Managing Director of Digital Law, a specialist law firm. And as you can imagine, we're currently busy advising our clients a lot when it comes to issues around digital data and in particular things like complying with data protection and other regulatory issues like everything from the EU Digital Services Act to how to sell your goods and services online. And we're looking forward to sharing some of our insights with you in this week's discussion in relation to some of the issues that are coming up in the news with regards to technology and digital as a whole.
Thanks, Peter. Yeah, so we'll just get straight into the news stories this week then. So the first one we're going to be discussing is the regarding the draft revised EU standard contractual clauses. So after the Max Schrems decision that was a couple of months ago now, so Max Schrems number 2, they decided that they were going to be redrafting the standard contractual clauses, and the draft was actually released probably a couple of days ago now. Peter will be able to confirm that, but so yeah, this draft is now being subject to a short public consultation period, which is running until the 10th of December. And they're going to then be taking into account all the feedback they receive on that, and then releasing the final version of the standard contractual clauses in early 2021. So just a few of the points that are included in the draft. It just imposes some obligations in regards to data subjects being provided with a copy of the revised clauses upon requests. And then interesting one about non-EEA importers and data processors who have the obligation now to inform the data exporter and EU data protection regulator of personal data breaches which are likely to cause and result in significant adverse effects. So those who affecting those who have their personal data in the EEA. Over to you, Peter.
Thanks, Laura. Yeah, so this is long awaited, the revision of the EU standard contractual clauses. And just to give listeners a little bit of an idea, these standard contractual clauses were originally dragged up in 2010 as a result of a court case. And in that judgment, the original standard contractual clauses were set out. But they're actually very detailed. They're actually quite large appendices how to make sure are present on any data transfer agreement that is put together. And there are specific ones for controls depending on the activities that they are undertaking. Interestingly, the proposal around these new standard contractual clauses is a little bit clearer on circumstances where organisations should be seeking to ensure that the standard contractual clauses are in place.
Yeah.
And it's also interesting that they're actually talking about the requirement to report data protection breaches. So, you know, this is relating to the fact that, of course, since 2010, we've now got GDPR. We've got a regime where a higher proportion of data protection breaches are now being reported across the European Economic Area. All of the data protection regulators have reported a significant uptick since 2018 in terms of the sheer volume of breaches that are being reported to them. I don't think it's necessarily the case that more breaches are taking place. It's just that more organisations are taking the if in doubt reported route rather than keeping their own counsel, which I think they used to be tempted to do before. But it's funny how a new fine regime that means you can be fined tens of millions of euros means that therefore organisations are going to be a little bit more careful and transparent when it comes to these breaches. And that's where it's interesting. The other thing in there, of course, Laura, where it's talking about saying that data subjects can ask to see a copy of these standard contractual clauses should they ask. So at the moment, an organisation might say, well, you know, we can't disclose a copy to you of the full data transfer agreement because it contains commercially confidential information or other confidential information. And instead they can turn around and in this instance go, well, actually, no, we will have to disclose to you these standard contractual clauses if asked. So it's fitting in with the world of GDPR, which has, of course, the enhanced data subject rights as a whole, bearing in mind you can make anything from a subject access request through to asking for your data to be rectified or deleted, or for a copy of your data so you can take it somewhere else. So it's fitting into the world in relation to data that we now find ourselves in. The other interesting thing to note in this is that originally the intention was that these standard contractual clauses would be in place by the end of this year, when of course now it looks like we're looking at early 2021. And of course, one person's definition of early 2021 is very different from someone else's. So we could be looking at January, February, March, perhaps. Who knows, it might take a little bit longer. But I think the other thing to flag up as well is the importance of making sure for UK organisations who are going to be receiving data from Europe in relation to their suppliers, in relation to contracts, in relation to data transfer agreements you may have, make sure that you are updating and adding these new standard contractual clauses. And in the meantime, before the end of this year, you might have to update with the old standard contractual clauses if they aren't currently in place on your agreements, because at the moment, with no trade arrangement, no adequacy decision confirmed, you need to make sure that these things are included. And I'm really concerned at the moment that not enough organisations have taken that step, and they might face a loss of access to their data come the 1st of January if they aren't careful.
Yeah, I think that last point was a really good one as well. I think it would have been easier for a lot of companies if this was done by the end of the year. But the fact that now it's going to be early 2021, it could mean that a lot of companies are then implementing the old standard contractual clauses and then having to fully review the contracts again and get the new ones in. So it could increase like legal fees and everything for the companies, but it's just something you have to do if you want to transfer data outside the EEA. Then that's just how it is.
Exactly, and that's the unfortunate scenario in terms of where we are. So it is a pain that we have to add these things in. We potentially have to do it twice. is the other frustration, but this is the practicality of where we are. Of course, this only applies if you're looking at data sharing between third parties. There are other arrangements if you're looking at sharing within an organisation, for example, that are available. But if there was an adequacy decision that follows a free trade arrangement being agreed, then this is then no longer as important when it comes to UK EU transfers. But in the meantime, the clock is ticking, and we've been expecting a free trade deal to be announced for the last 6 months, and it hasn't happened. So I'm now somewhat, even when we've been told, oh, there could be one tomorrow, literally there could be a deal announced on Friday the 4th of December. But check back in next week, folks, and we'll see if that's happened or not. My money's on it being not, but let's see.
Yeah, we'll see next week. So moving on to the next story then. So this is regarding iPhones and a security risk that could have been taking place. I think this issue was actually fixed in May, so this isn't an issue that is ongoing at the minute. But I mean, if something like this has happened once, it is a good thing to raise people's awareness of risks like this, because I think a lot of people, like me and Peter was saying earlier, a lot of people just assume that Apple products in particular are very secure just because they have like software built into them. I think anyway, this is what I've been told, but for things like viruses and things like that. But there is ways in which people get around into hacking into them. So Google Project Zero, one of their researchers, Ian Beer, actually revealed that attackers could steal emails, photos and messages, and even access the camera and microphones by using the Apple wireless direct link technology that a lot of us know as AirDrop. So AirDrop can be used by other iOS users. So when you are in sufficient proximity with other iOS users, it'll come up on AirDrop, and you can then send pictures, send files, and it's basically sending it without having to attach it to an email or something. So Ian actually exploited this network to show how hackers could gain access to the device. However, he had found no evidence that the vulnerability was exploited, but there was a lot of talk about this on Twitter back in May. So you never know if this did come to light, but Apple have fixed it now with an update, so hopefully that's fixed.
Indeed, a really interesting story this, because as you said, Laura, people tend to assume that Apple is a much more secure platform compared to alternatives.
Yeah.
And it just shows that, unfortunately, no platform is entirely secure or immune. And this is actually illustrating the fact that if there is a method of being able to access a device, be it via Wi-Fi, be it via the power socket, where of course there's not just power going in there, that usually allows devices to sync through a cable, all the way through to Bluetooth. You know, if there is a way of being able to communicate with the device, funnily enough, that can be compromised. And it's exactly the same here with the AirDrop, using that wireless technology to be able to gain access to the device. And as we can see, it looks like that Ian was able to get access to the device and basically had full command and control. I mean, if you're even able to access the camera and microphone and steal emails, you know, you can pick up pretty much anything that you want. And let's bear in mind as well that if you access the microphone, that means that you are able to pick up what's being said in conversations. You could potentially even access the mic in the device if the device is then sat on the desk where you're working, either at home or in the office, and could end up picking up other conversations that aren't even being used on that device. So it just kind of shows that where then there is a vulnerability, the level of risk is very significant. And this is just a reminder, really, that when you are using different devices, you are really under an obligation to make sure that the risk is minimized. So we talked the other week about the fact that your vacuum cleaner at home could be hacked. And even though it doesn't have a mic on it, you can, using the sound waves that those vacuum cleaners emit to try and stay away from banging into bits of furniture, it turns out you could work out from those sound waves and what was being read, you could piece together people's conversations as well. So if you have an electronic device, it's at risk. It could potentially be compromised. So we need to think about this when we're thinking about where we're going to work, be it in the office or at home. And we also have to bear in mind the suitability of different devices and platforms when it comes to carrying out business communications in particular, because if it's been compromised, you could then be in breach of data protection legislation. You could certainly be in breach and certainly running the risk of being compromised from a cyber security perspective. So there's a lot to bear in mind on that, and no device is immune. No device is 100% secure. So this is just a little reminder of that.
Yeah, absolutely. And I think it would be wise just to, well, with iPhones in particular, you can turn the AirDrop feature off, which I do all the time, because I've accidentally sent photos to people who I've been sat next to and thought, why the hell have I done that? Like, I didn't mean to. So it is easily done. So, and as well, like things like Bluetooth might be best just to keep that off while you're not using it. Because people could connect to such things, and that is a way of people getting into the device. Just like when you go out in public and accidentally connect to a Wi-Fi network, I just always turn my Wi-Fi off as soon as it comes up on my phone saying there is a Wi-Fi network, because I don't want to connect to it.
Well, there you go. We all need to be sensible like Laura. Is the answer.
Yeah, so moving on to our next one then. So this is one of the scarier ones of this week. So this is the Amazon's Panorama Box, which is letting firms check if staff follow coronavirus rules. So basically, Amazon are planning on selling companies a way to detect when staff are not wearing face masks or when they're not socially distancing. So the technology is in fact in effect, an add-on, a retrofit in a box to existing security cameras that can draw on the off-the-shelf AI apps to actually figure out when people are wearing masks or when they're too close to each other and things like that. So there has already been some privacy campaigners who have raised issues about this and concerns, and have raised the fact that this is kind of another way of surveillance on staff. But Amazon have actually refuted the characterization of its new product as a surveillance tool, and have basically said that it is completely safe, and it's not surveillance, it's just checking up on people.
Thanks, Laura. I love that. It's not surveillance, it's just checking up on people. Or surveillance, as it's otherwise called. I mean, you wonder whether it is with Amazon. They're not content with putting little devices in everyone's home where you can actually pay for the privilege of having your conversations listened to by Jeff Bezos and his staff at Amazon. They're now selling devices whereby they can, organisations could use their technology to then see, right, are our workers at home wearing masks? Are they looking at the laptop, or are they doing something else? I mean, some people have ended up, when they've been working from home this year, they've been told that they've had to log in, even though they've had no work to do. So, they've been thinking if ordinarily they could just go and do something else. But as it is, they've found that no, you have to log in and regularly open something or do something on the system, even if you've had no work to do. Such is the level of sort of control that some employers like to exert on their employees. And now it turns out that if you are one of those employers, now you've got all this little box of tricks, so you can see exactly what your staff are doing, and as you say, check up on them. I mean, this isn't the first time we've looked at surveillance in the workplace. A few years ago, it was common that apps were being developed that could see what, if an employee is looking at a screen, it was trying to work out, well, whereabouts on the screen is the employee looking? Are they looking at the area on the screens that they should be, if they're doing their job? It was even trying to work out if employees, if their eyes were sort of dipping and if they were falling asleep in that sort of 2 p.m. wall after lunch when you might sometimes nod off. They were trying to pick up if people were doing that. There was even technology developed where you could have a device under a desk where they'd work out if the employee was sat there or not, or if they'd gone off for a coffee or to use the bathroom. That sort of invasion into privacy has happened within organisations before. And now here's Amazon allowing you to take it a stage further and allowing you to do that when the employee's at home. Wow. And this is a danger when we've got, we're working from home now in this year of the pandemic. And yes, that means that there's this sort of level of surveillance potentially where the employer can almost come into the employee's home when it comes to potentially this level of surveillance. So we know that Amazon has quite invasive surveillance of its staff who are working in their fulfillment centres, from the sort of the fly on the wall documentaries we've seen where people have gone in there and shown the targets and the pressure that staff are under physically working at Amazon. Now it turns out that you use Amazon's technology to bring that level of fear to your own business as well, if you really wish. So there you go. That's what Amazon's Panorama Box can potentially do for you. Not scary at all.
Yeah, absolutely not. I think things like that, this in the workplace where there is already security cameras in place, this might be helpful in a way, but I suppose in a way as well, like sometimes social distancing can't be avoided when you're walking past somebody or wearing a mask. Like you might take your mask off just for a moment and then put it back on whilst you're at work, or you might be working in a room where nobody's there. Things like that, you should just trust your employees that they are following the rules and doing it correctly. It's going a bit far to actually watching them and making sure that everybody is following the rules. It is a bit far, I think.
Yeah, indeed. I think it's also actually indicative of the kind of clash between Europe and America when it comes to privacy. This stuff, seems to come out of America on a regular basis where this technology is being developed, and they do not see a problem with it. And I don't know if that's perhaps in the US where there's not been a history of the sort of abuse of data or the abuse of people's liberty and freedom, which has been the case in other countries over the centuries. So you tend to find in, for example, Eastern Europe, they have quite draconian laws when it comes to gathering data on people and how it's used, because they've had governments that collected data on people and then used it for the purposes of suppressing their population within living memory. Whereas in the West, that isn't something that's happened for centuries. So it seems to be less in the public consciousness. But it means that Europe as a whole is developing legislation, things like GDPR, like the Data Governance Act, like other things that are being that are in the works, that mean that generally they are more regulated when it comes to the collection of data like this, whereas in the US it's just not a consideration. It's not seen as being a problem, because they've not necessarily thought about how it could be misused, perhaps. But I think that's the sort of dichotomy here, and there's that increasing tension between the sort of US law on one side and European on the other, and a sort of tug of war back and forth, and this is just another manifestation of it.
Yeah, absolutely. So moving on to our next story then, but kind of staying on the data privacy side. So this is a story regarding the New Zealand's Privacy Act of 2020. So this replaces the, if I'm correct, I think it's the Data Privacy Act 1993 that was in place in New Zealand. So this was brought into effect on 1st of December. And the rules apply to data handlers based in New Zealand, as well as any overseas organisations that carry out business or collect data relating to New Zealand citizens. So that's very similar to GDPR, how if you are collecting and processing data of EU citizens, GDPR does still apply. So the Privacy Act mandates that organisations must report all serious data breaches immediately if there is a risk of harm. I think in the story as well, it mentioned how risk of harm was not defined under this act, but they are saying that this is when data kind of leaves their organisation and goes out into the public, so other people can view this data. And I think one of the most important things here is the fines that can be given. So data handlers can only be fined up to 10,000 New Zealand dollars, which is quite a big difference compared to the other data protection regulation. Obviously, GDPR, you can be fined tens of millions of pounds or euros. But they have mentioned that if a particular case is of such extreme nature that it does actually breach a lot of rights under the Privacy Act, the Privacy Commissioner can actually take this and make a complaint to the Human Rights Tribunal, which then can give an additional fine of a maximum of 230,000 New Zealand dollars, which still isn't even as much as it would be in the UK under the old Data Protection Act.
Indeed, thanks, Laura. I think this is absolutely fascinating in the context of, people are thinking, well, why are we talking about the law changing in New Zealand, which, when in comparison to the global economy, is of course a comparatively small cog. But I think this is interesting because New Zealand has been a leader when it comes to data protection legislation and data protection practice in the past. Let's not forget that the EU, which prides itself on its high standards in relation to data protection, given it had its EU Data Protection Directive in 1995, and which introduced a lot of data protection standards across Europe. There's the forerunner of GDPR coming in 2018. But New Zealand was one of the first countries outside of the European Union to benefit from an adequacy decision, which basically means that Europe's then said, right, we are going to allow data of EU citizens to freely flow to New Zealand and back and forth without any impingement. No need for those standard contractual clauses we were talking about at the top of our podcast today, for example. So that's a big benefit, really, for European and New Zealand businesses. But that adequacy means that Europe is saying we feel that the data protection laws in New Zealand are adequate and therefore are sufficiently rigorous that therefore it's fine to have that free flow of data. Yet we're looking at this, and this is saying fines of just 10,000 New Zealand dollars. And even if it, even if you make that official complaint to the Human Rights Tribunal, which by its definition, if you then make a complaint to the tribunal and they say yes, your human rights have been affected, that's a pretty serious thing. When someone's human rights have been affected, their privacy has been compromised, and we're going to say the maximum fine of $230,000. Let's not forget that British Airways was fined £20 million by the Information Commissioner in the UK this autumn in relation to a data protection breach last year. Marriott Hotels being fined £18 million. Kind of puts into perspective that a couple of $100,000 New Zealand dollars.
Yeah.
And I believe that, before our listeners in New Zealand turn around and write in on this, I believe it's about $2 New Zealand dollars to the pound. So you're looking at, less than £200,000 there if it goes to the tribunal, or less than £5,000 if it goes to for an initial fine. For organisations, and let's not forget, Google, Facebook, all these corporations are operating in New Zealand. So I'm sure they're really worried about getting a fine of 10,000 New Zealand dollars potentially. So it does seem to be totally out of kilter compared to the quite large levels of enforcement that we're seeing under things like GDPR. And like I say, this wouldn't matter were it not for the fact that it's the adequacy decision, and not for the fact that Britain is hoping to get an adequacy decision from the European Commission to allow for the free flowing of data from Europe to the UK. You might think, well, how does that affect me? Well, for a British organisation, if you've got data stored in the European Union, even if it's data of British citizens, if you're using a system where its servers are based in Europe, you might have a problem accessing your data. So even if those servers are in Dublin and your servers are, with Microsoft, make sure you've got those standard contractual clauses in there, because without an adequacy decision, that's going to apply. Yet, as I say, in comparison, the laws here in New Zealand seem nowhere near as rigorous or robust as what we have in the UK under our Data Protection Act 2018, that writes GDPR pretty much chapter and verse into UK law with some important caveats and clarifications, of course. But the point is that in terms of a data protection regime, what we have there in New Zealand seems very, very different compared to in the UK. Yet the UK is really worried that it might not get that adequacy decision, which we're now on the 3rd of December. If that hasn't come through by the 31st of December, that has massive implications for the supply of data services to the UK from facilities and infrastructure based in the European Union.
Yeah, absolutely. I think it is good that New Zealand are taking these actions and keeping their laws up to date, because obviously they've got to show that they are keeping up to date to maintain their adequacy decision. But like you said, the fines are considerably low compared to other fines across the world or even across the EU. So it doesn't give much of a deterrent, should we say, as to stick to these rules, basically, especially for the large organisations. Like the smaller organisations, 10,000 New Zealand dollars may still be a significant fine, as it would be in the UK for some small organisations. However, for those bigger ones, like you said, like Facebook and Google and things like that, it is very, very small.
Exactly, and it's just as well when we look at the context of adequacy in the UK. One of the reasons I think why they're saying that we can't, there's a problem, is potentially because of the surveillance laws in the UK. The other sort of and finally bit as well is just to add that Matt Schrems has said this week that if there is an adequacy decision in favour of the UK from the European Commission, he won't end up suing over the decision, which is very cool, isn't it? But he basically said, I won't end up suing over it because I'm sure someone else will, due to the highly invasive security and surveillance laws in the UK. So even if we get adequacy later this month, how long will it last? Will this be something like, will it be affected in the same way that, for example, Schrems has taken down the mechanism for sharing data between Europe and America in his two big court cases so far? Will someone end up doing a similar thing with regards to data sharing between Europe and the UK? Let's watch this space, I think.
Absolutely. So moving on to the next one then. So this is a story about slow broadband. So it's said that 1 in 5 households in the UK are struggling with less than a legal minimum broadband speed. So since March this year, since a lot of people have started working from home, every home and business has now the legal right to a decent connection, an internet connection. So this is 10 Mbps. So if you cannot get this speed, you are legally entitled to ask for an upgrade. I'm not sure if that means you have to pay more or something, but I'm guessing that it means that companies cannot offer you less than the 10 Mbps. So Ofcom have said that only 2% of homes in the UK do not have access to this internet speed. But thinkbroadband.com, which is a tester of internet speed as well, have said that up to 21% of people actually fail to get this speed. And they've said that some providers are just very bad at telling you what is available. You may have fibre available in your area, but your provider just hasn't told you. So it is worth just asking people and asking about it, because like I was telling Peter earlier, we was with a different company for our Wi-Fi a couple of years ago, and we had to keep on ringing up and asking for our speed to increase. We kept on testing it online and it was really low, and every time we rang up it'd be increased and then it'd be put back down. So it is worth just asking if you do have really slow Wi-Fi, because now you have got the legal right to that as well.
Thanks, Laura. Yeah, I mean, it's interesting. I mean, 10 Mbps, 10 megabits per second is not particularly fast.
No.
But at least it's saying, look, you have that legal right to it. But I think that it's quite interesting here that the fact that Ofcom's saying, oh, 2%, it's only 2% that won't have that access, but Think Broadband's saying, well, actually, it's far more people that fail to get those speeds. And this has been a real problem for those who've had to try and work from home and get by on using networks at home that really aren't necessarily provided for the sort of bandwidth you might need if you are working in an office. I mean, particularly for those in the digital and creative sector where you're working on video editing and uploading video and audio and doing quite complex things. This has meant that sometimes we've not been able to do at home the things that you ordinarily would have been able to do when you're in the office. And it's meant that this year has really affected the sort of thing that certain people in certain industries have been able to do as a result. And yet here it's saying, yes, we have this legal right, apparently, to be able to say that it is illegally slow, that we haven't got a better service here. But of course, there are certain parts of the country where they simply haven't got the fibre broadband, simply isn't available still. And I mean, Laura, you were saying that the village where you live, I mean, it's not as though you're living in the wilds of Northern Wales or the Highlands of Scotland or on the Isle of Skye or something. You're living in albeit in a village, but in a place where people very often are driving from there to go to work in Doncaster, Barnsley, Sheffield, Rotherham, yet that they can't necessarily access decent speed broadband at home.
Yeah, so I live in a little, I think it's classed as a town, but it is more like a village in Doncaster, and yeah, we can't get fibre. I know that other people can in our area, like in Cuddiesborough, which is just down the road from us. You can get fibre there, but not near us. So whether that's just where I live or something, but yeah, you would think that all these built up areas would have this by now. So yeah, I think it is just important, because especially from when I'm working from home, I'm lucky that I'm the only person who's working from home. My parents don't work from home. They're able to actually just go to work still. So if it would have been the other case and there'd been like 3 or 4 of us in the house trying to use the Wi-Fi at the same time, it probably would have proven difficult.
Yeah, I suppose you just got to hope that when you're home, that your brother isn't at home or streaming a movie or trying to play a game or something. Because the amount of available bandwidth for that, in that case, would then mean that, for example, being able to do a video conference like this would get very, very difficult.
Yeah, absolutely. And I bet a lot of people have found that. We always discuss about like the problem of people walking in or not being able to have a private space to work from home. But I think the most important bit is the Wi-Fi connection. I think that if you don't have the Wi-Fi connection, then you just cannot work. So yeah, it's very important.
I mean, we should probably just tie this in as well to the people remember from earlier episodes where we talked a lot about the government's levelling up agenda and the idea of being able to have more money spent on infrastructure, particularly in the north of England, and that included things like fibre broadband, and saying that this is something that everyone should have available to them. And I'd say largely it's you know, towns and villages exactly like where you are, Laura, where this sort of facility should be provided. Yet, of course, we've also had this year the government reversing its decision with regards to allowing the Chinese broadband company Huawei to provide infrastructure. So actually, in some areas, speeds might actually fall as that Huawei kit is stripped out of the network and then replaced with new equipment. So it might be a matter of taking sort of one step back to then take 2 steps forward to hopefully then eventually be able to get the actual proper high-speed internet that people now are clearly going to need. But it's regrettable due to a political decision there. You know, Huawei, albeit as a Chinese corporation, were standing ready to be able to commit to provide this investment and to work with the British government to provide good broadband coverage in some of the more outlying areas, and now it's going to be a lot more difficult to press ahead with that priority.
Yeah, absolutely. So moving on to our next story then, just so this podcast isn't too long today. So this one is regarding a new tech regulator that's going to be brought in the UK in order to limit power of Google and Facebook. So the Competition and Markets Authority will actually gain a dedicated digital markets unit, which have been empowered to write and enforce a new code of conduct or code of practice on technology companies, which will set out the limits of acceptable behaviour. So it's not yet clear to who this code will actually apply to, but it will affect those companies who have deemed to have strategic market status. So these big companies like Google and Facebook, and it's not yet been decided what that means in terms of the limits that will be put on them, nor what restrictions will be imposed.
Thanks, Laura. So yeah, just a quick story here is that the Competition and Markets Authority is responsible for all competition in markets across the economy in the UK. So of course, in terms of the digital economy, I think it makes sense that they're setting up this sort of sub-unit to look specifically at digital markets. However, it's interesting that it's only looking at those with that strategic market status. And that reflects, I think, the EU Digital Services Act, which is looking at trying to introduce limits on what it calls the gatekeepers, the Amazons, the Facebooks, the Apples, and how they are using their market status. And it seems almost as though the UK is saying, well, we won't be implementing the EU Digital Services Act now that the UK just left the European Union, but it's almost considering in parallel, well, what should we do? However, it's interesting that the UK could potentially be a lot more agile here in terms of reflecting the need to reflect some of to regulate some large tech corporations in a more in a better way than has been the case in the past. But the UK might be able to move comparatively quickly on here, whereas the EU is only about to publish for the first time its new act on EU digital services this month. And even then, it might take several years of lobbying until anything's actually then passed by the European Parliament, and several years after that before it actually takes effect. So there's an opportunity here for the UK to actually lead in creating an adequate system of more light touch, commercially focused regulation, putting correct market-friendly limits on the power of the large tech corporations, but perhaps in a more commercially friendly manner than might be the case in other jurisdictions. So it'll be interesting to see how the UK exploits its status in that regard now it's outside of the European Union.
Yeah, absolutely. And I think we mentioned in last week's episode that the Digital Services Act should have been released in the draft form this week, but as you said to Peter earlier, it's nothing has been heard of yet, but they are expecting it to come out in the next week or so, but we shall see.
Indeed, the dates I'm hearing now are something like the 10th or the 12th of December potentially, so we might get something next week, but similar thing with regards to the EU free trade deal with the UK. I'm not holding my breath.
No, absolutely not. So this is the last story we've got time for today. So this is sanctions for companies for Carrefour in France and Carrefour Bank. So this is a large organisation. Peter actually told me about this earlier. They're quite like big supermarkets in France, kind of like our big Tesco. And they have the CNIL, the regulator, have actually received several complaints against the group over the past year or so. So they decided to carry out checks and investigations into the companies between May and July of 2019. So after these investigations, CNIL actually noted that the shortcomings in the processing and customer and user data. So Carrefour France was actually sanctioned with a fine of 2 million euros, or over 2 million euros, and Carrefour Bank was actually sanctioned with a fine of 800,000 euros as well. So these fines were in relation to many breaches, some of which were to do with cookies, obligations to inform, so under Article 13 of GDPR, and failure to comply with limited in the data retention period of data. So there wasn't an actual data breach as such, just breaching the rules of the data protection regulations of Europe.
Thanks, Laura. Yeah, I think the key bit here is that last bit that you mentioned. The fact that the fines are comparatively small. I say comparatively. Now, when someone amounts to a fine of 2 million euros, you think, oh, that's not very big, is it? When we have fines of 50 million euro and 20 million euro within the last 2 years, 2 million euro suddenly seems a small change. But also the fact that this was over a lack of transparency, so failure to inform data subjects with regards to things like cookies and the surveillance there, and failure to comply with things like data retention. I think we just flag this up because a number of times, Laura, we've sat down with clients who are coming to us with great use cases. How long are you going to be keeping your data for, so we can confirm this in your privacy policy? And very often they look at you as though you've got two heads and go, oh, well, we were going to keep it forever. And you go, you can't actually do that. And it's a basic fundamental principle on GDPR. You only keep data for as long as you need. So if you end up not limiting that lifespan of the data, this is what's going to happen. So you could end up realistically then with a fine like this of several million euro.
Yeah, absolutely. Yeah, I think it's good to mention that, Peter. A lot of our clients, the most common answer is either I'm going to keep it forever because I don't know what else to do, or please tell me how long to keep my data because I haven't got a clue.
Exactly. So it's very often, and it surprises me that very often it's the start of that conversation with them. I would expect them to be turning around and saying, oh, well, we're going to keep our data for 3 years or 6 years. Is that all right? But very often it's us initiating it, which surprises me when we're talking to, what you presume are highly experienced developers very often, particularly in the sort of tech startup field. You think, well, we're having a conversation about how many other products and projects have you worked on where it's just data being collected and then kept indefinitely, and no one's actually raised this as being a problem. So, want to flag up, and please to all of our listeners and viewers out there, spread the news on this. Turns out you can't retain data forever, personal data. You do have to have a finite lifespan on it.
Absolutely. So that's everything we've got time for today. So just before we finish, we just want to remind you about the special offer we have on for our listeners. So this is the GDPR Compliance Manual for Legal Practices. It was originally come on sale in May of 2018 when the GDPR came into force, and this was originally on sale for £195. It's now down by around 50% off to £99. So it is available in digital copy and hard copy as well for an additional £5 for postage and packaging. So I'll just pass over to Peter just to give you a little bit more information about this.
Thanks, Laura. So once again, this is our GDPR manual that contains forms and templates and checklists to help organisations that may be coming to GDPR and thinking, how do we demonstrate compliance with this thing? This gives you the tools to help you work out how to comply and what that compliance should look like. And it raises things like data retention and suggests that you have a data retention period enforced across your organisation. So yes, if you're using our GDPR manual, you wouldn't end up like Carrefour and retaining data indefinitely.
Yeah, absolutely. I think that is a key point. I think a lot of people don't really understand what GDPR does or what it means. So our manual just kind of takes GDPR and kind of puts that into more practical terms and lets you know what you can do in order to comply with it. So yeah, that's everything we've got time for today. So thank you once again for listening. Just a reminder as well, this is available on as a podcast and a webinar. So you can find it through our website, our YouTube channel, or any podcast channel you may listen to. So thank you for listening, and we hope to see you next week. Goodbye.